Hello everyone, myself Tushar and I am currently a legal intern at LEXIS and Company law firm and I am pursuing BA from JCCLC Kolkata. So today I am going to talk about the general defenses and tort, and especially the first defense, and I am going to talk briefly is Volenti non-fit injuria. So in the previous class we have discussed about the general defenses and tort, and let us recap that at 8 general defenses as quickly. So the first general defense is voluntary non-fit injuria. Second one is plaintiff is the wrongdoer. Third one is inevitable accident, and fourth one is vis major, that is act of God. Fifth one is private defense. Sixth one is mistake. Seventh one is necessity, and eighth one is statutory authority. So these are the basically 8 kinds of general defenses in tort. So in today we are going to talk about voluntary non-fit injuria, which is the first as defense in tort. So what is voluntary non-fit injuria? So voluntary non-fit injuria, we can literally say that to one who volunteers, no harm is done. This is the literal meaning of voluntary non-fit injuria. So which means that that the plaintiff has waived his rights and now he can't complain. So the plaintiff has waived his rights and now he can't complain because he has consented for the act. So the consented for the act and there are famous case laws in this regard that at the what is consent, what type of consent is required in voluntary non-fit injuria. So consent can be express or implied. So what is implied consent? So basically there can be consent and which can be expressed or implied. So what is implied consent? So to understand the concept of implied consent, we have to understand some of the famous case laws. The first case laws is Hall versus Brooklyn. So what Hall versus Brooklyn Auto Racing Club. So what in this case is so what happens in this case is that there is a racing club named Hall versus Brooklyn, and there is a person named Hall who visits this racing club to watch the races between the cars. So during the match some accident happens and this person named Hall got hurt. So Hall took up the matter to court and filed a suit against the racing club. But the court observed that this is a case of voluntary non-fit injuria, and said that when you have bought the ticket for the race is you have impliedly given your consent and to the racing club, and you have consented for the any harm which could happen inside the racing court. So court denied him compensation. The second famous case law is Padmavati versus Dugganaika. So basically in this what happens that there is a lorry driver who which and from the lorry driver two persons asks for or so in this case law where basically what happens is that there was a lorry driver and two persons come and ask for lift, and they got into the vehicle, and suddenly the vehicle met into an accident, and these two persons were injured badly. So they took up the matter to court and asked for compensation from the lorry driver. So but the court denied them compensation because they said that you are the only ones who asked for lift, and so when you asked for lift you consented any harm because the driver was not negligent. The accident happened because his tire broke off. So the court denied them compensation. So first thing is this, and the second thing is this: the consent and should not have been given on the basis of fraud or under any compulsion. So the voluntary non-fit injuria, this is whole term depends upon the consent. So the consent cannot be taken by fraud or any other compulsion. So we have to understand this. We have to see a very famous case law, which is R versus William. So in this case there was a singing instructor, and he said to his underage female student that we should do a act together to free your vocal cords. So basically that act was sexual intercourse, and to do those, and so basically basically the consent was obtained with fraud. So the court denied voluntary non-fit injuria in this. And second, and now what there is also an exception to voluntary non-fit injuria. So the rescue cases are always an exception to voluntary non-fit injuria, because if to understand this concept, we have to look into a very famous case law, which is Haynes versus Harwood. So basically in this case was what happened that there was a servant, and basically there is a master servant relationship, and his servant took the master's horse to the market and left it unattended. So what happens is that the horses has ran off and injured many persons in the market. And to stop those horses, a policeman stopped those horses and got himself injured badly. So the matter went to the court, and the policeman asked compensation from the master due to the acts of his servant. So the master said that this incident cannot be unforeseen. I cannot predict these incidents, because there is no chance of my horse getting mad. So the court said that no, you can predict this type of incidents and you can't left these horse unattended. And secondly, he said that okay, the policeman has consented for the harm, and by stopping my horse. So because of this, I am not liable, because voluntary non-fit injuria applies. But the court said no, the voluntary non-fit injuria will not apply, because he is trying to solve your mistake, the mess you have created. So you have to pay compensation to him. So thank you guys, that's all. And this is Tushar signing off.